Hi, everyone. So we have two elements that we have not had yet in this panel. We have a PowerPoint. Oh, no, we have had that. We have a PowerPoint in the room, and we have a speaker coming to us from California. So I hope that the technology is working, and I'm looking forward to starting. So good afternoon. I'm honored to be joined by this stellar expert panel and to begin this conversation about coercive control, lethality, and femicide. And we could not have had a more perfect introduction by the amazing Stephanie McGraw that we just heard. I would just like to reiterate, first of all, the trigger warnings that we have already given earlier today. As it should be clear from the name of this panel, we're certainly addressing traumatic topics and personal experiences. And I urge folks to engage in self-care and to see our resources on the HOVA site. And I'd just like to briefly introduce our esteemed panel, whose full bios you can read also on the HOVA site. To my left, Chitra Raghavan is a professor of psychology and director of the Forensic Mental Health Counseling Program at John Jay College. She is a leader in the field, conducts groundbreaking research, and testifies regularly as an expert witness. Tanya Selvaratnam is the Senior Director for Gender Justice Narratives for the Pop Culture Collaborative. Tanya is also the author of Assume Nothing, A Story of Intimate Violence, about her experience being in an abusive relationship with the then New York State Attorney General, Eric Schneiderman. Anna Maria Diamante has dedicated her legal career to justice for survivors. She is a member of the Family Law Roundtable, an expert in family law litigation, and is the director of the Family and Matrimonial Practice at Her Justice. Paula Cohen, joining us from California, is also an expert practitioner in this field. She is a senior attorney in the Supporting Families Work Group at the Legal Aid Foundation of Los Angeles, where she has served survivors for over 25 years. So I'd like to dive right in and first, ready?
Yes, I'm looking for my phone because I'm determined to keep it to 10 minutes.
Okay. So it's turning first to Dr. Raghavan. Can you start us off by talking about coercive control? What is it? How do you define it? And how do survivors experience it?
Hi, folks. I'm delighted to be here. And so I'd like to start very quickly with a historical definition of partner violence, because that will actually help inform why we're stuck. Historically, we defined it as essentially physical or psychological abuse. And we counted it. So how many times did he hit you? 5 times in the last 6 months? Let's add that up with how many times did he yell at you? Twice? All right, 7. How about you? 15? Okay, you had it worse than her. And so, and this remains, by the way, the dominant way of measuring partner violence in most parts of the world, in many parts of the US. And it's problematic because there's lots of missing data. You miss the nuances of abuse dynamics, you misclassify perpetrators, you misidentify victims. For example, when women use violence, and many do, it's seen as evidence that partner violence is not gendered. Or we're often dismissive of same-sex violence simply because we don't know how to measure it. And we misclassify incidents as minor, but if we actually understood the context, we would know that the cold look, the silence, the breaking of a teacup was not minor, but extremely severe in the context. And this missing data ends up where the partner violence situations are invisible to police and the courts, which leads to essentially the victim credibility, because the data are missing. So we ask questions, and these are questions I'm asked in court all the time. Why state abuse was so bad? Or why disclose sexual abuse so late in the investigation? I am currently doing multiple cases with the latter. Which brings us to the utility of coercive control. And in a nutshell, it increases sensitivity to partner violence, and very importantly, it really gives us a better framework for understanding what might seem like incomprehensible victim behaviors, but also traumatic outcomes. I'd like us to sort of pull back a tiny bit and conceptually think about what undergirds coercive control as a power dynamic. And it's a power imbalance that is continuously exploited. In other words, it doesn't come and go. It's not a one act thing. It's in the relationship throughout. And the way perhaps that might be helpful to think about it is it's like an electrical current. It's always that it's aversive. It's the woman or sometimes the man or trans are in pain. But every now and then there's kind of like a voltage that goes up and there's an act that's really frightening, intimidating, and then it goes back to a level where it's unpleasant, but it reminds the person of what's happening. So my students and I call that looping and autocatalyzing. What we mean is one act goes to another, to another, to another. It's always looping. It doesn't stop. And sometimes one act can catalyze another, sort of get the other tactic to start to feel important. It happens in all situations. It's pervasive. And importantly, the abuser has privileged knowledge. He knows what she's really frightened about, what hurts her, what she's embarrassed about, what she's humiliated about. And those are the areas in which he really pushes down deep. Some coercive tactics are very obvious, like having injuries from being beaten or screaming loudly, but many are invisible. And those little invisible things are the glue that eventually trap the man or woman. And of course, it's context dependent. So I do want to say that coercive control is not the same as a controlling behavior. It's different. It targets all domains. It's not just that the abuser is having a bad day, or, as a lawyer once said to me, he was feeling kind of moody and, wow, you're so histrionic, you don't get it, give the guy a chance. No. In normal relationships, no relationship is normal. In healthy relationships, when there is control, there's usually negotiation. There's give and take. You might lose today, but you might win tomorrow. In a coercively controlling relationship, there's no negotiation, or if you try, the resistance is met with increased coercion and increased retaliation. Things get worse for you. And so you eventually stop, right? That's a big difference between coercive control and normal control. Another important difference is, what is the end goal of coercive control? What undergirds this power imbalance? And we know one, but we forget the other. And we know that the end goal is dependency and submission, so that she stays or she behaves, or that she's obedient, in some cases he. But there's another really important goal where the abuser needs to be validated as correct. That is internal to the psychology of abuse. The abuser needs to know that he's correct. He wants to be affirmed. And a great deal of what happens in coercive control is to get that affirmation. Well, if the abuser is affirmed as correct, then automatically the victim is seen as unreliable. I'm going to go through, so my students and I divide the coercive control tactics into 8. There's different ways to do it. We do it this way because we want it to be available and accessible to front responders. And by that, we mean law enforcement, people in emergency rooms, the first time you're evaluating a client, young lawyers, but also social workers doing the first screen. So it needs to be accessible and usable. It's a very complex construct. And I'm going to run through these 5 quickly, and then I'm going to try to give you an illustration of how they loop, catalyze, and work together. So what is surveillance? Essentially, it's keeping tabs until the woman or the victim's private and public space are reduced. And by reduced, she feels that she's being watched all the time. So this could be physically stalking her, or also checking social media, phone, GPS on the car, all sorts of different ways. So there's a feeling that he's constantly present. Isolation is essentially, you have difficulty reaching out for help because you don't have a very good social network. And this can happen because he surveils you. This can happen because he sweet talks you, seduction. This can happen because he makes himself a nuisance. He embarrasses you at parties. He blows up when you're on the phone. He makes it so difficult that you just stop. It's not necessary that he has to take the phone away. He can just make it impossible. But there's another form of isolation that we don't much talk about, which is internal. If you start to be surveilled and you start to be anxious and nervous around him. At some point, you stop feeling that you can actually help anybody. You might have people you could call, but you start believing that they won't help you, they won't believe you. And the sort of inward facing isolation is just as important as the outward facing. Microregulation, as the name says it, it's constant, trivial, unpredictable demands, strict rules or details that you can never get right because you're not supposed to get them right. And they are little things like how you walk, how you talk, what your hair is, how you wear your hair, your lipstick, the way you tell jokes, which leads deprivation, another tactic. It's rarely measured, and it's easy for lawyers to measure this. Access to shelter, money, medical care, sleep, it's an important tactic. And typically these happen and are woven through the relationship so that the woman is often not in a place to resist. Degradation, it's sometimes known as psychological abuse. We call it degradation because really what happens here is the core of who the woman or the victim is being attacked and degraded until you lose a sense of who you are. And this could be done by name calling, blackmail, but also a lot of the other things I've talked about. Let me sort of try to put together a composite of the last 10 cases or so I've done. They've all had intimidation, manipulation, and sexual abuse. Intimidation, what is it? At its core, it's the creation of fear. So how somebody creates fear, but it's also how you create dread and anxiety. Dread is really undervalued. Dread is when you're afraid something will happen. And dread is a much more powerful emotion than fear because what it does is it paralyzes you and it keeps you from doing anything. If I do this, will he hit me? If I do this, will he rape me? If I do this, will he embarrass me? So you pull back. And intimidation is essentially the creation of fear and dread with or without physical violence. The threats of force, often past remembrances, and which leads into manipulation. Very simply, manipulation is rewriting your reality so you doubt yourself, you question yourself, or you sort of stop, you give up trying to present your perspective. And what does it do? Essentially, you give in because you're afraid, or you give in because you don't know how to act. You doubt your reality, which means you're losing autonomy and agency. You blame yourself for what's happening. And little by little, you rely on your abuser, either because of paralysis, because you're afraid, or because you doubt your judgment. It sort of doesn't matter how you get there. It's sort of being attacked in different ways, which validates him as correct. No matter how you get there, if you ask him for something, you're validating him, and that's what he wants. Sexual abuse is very powerful. It happens, we know, in about 40% of abusive relationships. It's invisible. It happens in the private domain. And women typically don't have language to describe it. And most women don't know that it's the law. Why should you? And because of that, women start by feeling confused, overwhelmed. Is this really happening to me? It's often interspersed with tenderness, making it more confusing. What many courts perhaps don't know is that when there's any kind of sexual violation and there's a loss of bodily autonomy, shame will creep in. This is an evolutionarily programmed emotion. With that comes emotional paralysis, and with that comes covering up the abuse. These things happen not because often women don't know, and often women are deeply embarrassed, but it's also because we're programmed to cover up things that we're ashamed of. And that's automatically a loss of agency. If we put this all together, and I can't read my own PowerPoint. You get the idea. You're ashamed, you're paralyzed, you're hesitant. It's coming at you in all different angles, and one thing catalyzes the other. And the end goal is you're silent. And if you're silent, he's validated. Why go to so much trouble? Why not just, hit her hard and many times? Because psychological captivity is much more powerful, and it's much more durable, and it confuses free will. And women and other victims start to wonder, did I ask for it? Why did I not protest? Did I consent? And throughout this kind of confusion, one, you don't look good in court. Two, you don't know what to tell your lawyers or your social workers. You tell them much later in the process, which then makes you incredible and makes them look good. So to summarize, we should measure it as a dynamic. It is possible. And why? Because we actually get the women's experience the man in a much more accurate way. And I say this everywhere, every time with anybody I can tell, the burden of establishing partner violence should be with the evaluator, not the victim. We would never ask a man or a woman who's been embezzled on the stand, hey, can you please work out the legal ways in which you got embarrassed to make my job of prosecuting you easier? But why do we ask women? And why do we then tell them that they're not credible when we ask them to make the case on the stand? This is bias and double standards. So, as inspiration and maybe a little challenge, we should be the ones doing the evaluation and properly. Thank you.
So I could listen to Chitra all day, and also I just had like my mind slightly blown right there. So thank you for that. That was amazing. Tanya, I'd like to turn now to you and your experience. You came forward publicly and exposed the domestic violence that you were experiencing in your relationship with Eric Schneiderman. Can you tell us about that and how coercive control, and I feel like Chitra just basically.
I mean, I picked excerpts from my book, not knowing what you were going to talk about, and I'm kind of shuddering on the inside, in a good way. You know, this is the camaraderie. But it was 5 years ago, a little over 5 years ago, that I first spoke with you, Jennifer, about what was happening. And I remember you said to me many times that I have to go through an unbrainwashing, because the coercive control had sunk in so deep. And that when you were talking, that just came to my mind. So I'm just going to read a few excerpts from the book that illustrate kind of coincidentally what you were talking about. Early in our relationship, he told me that he could tap my phone and have me followed. Because he was the Attorney General of New York State, I knew he had the power to do it. His power was a thread that ran throughout our relationship. Over the course of about a year, I had been broken down by the slapping, spitting, and choking that he had inflicted on me during sex, never with my consent, and by his gaslighting, which had destroyed my self-esteem. Often, when he looked at my chest, he would tell me to see his plastic surgeon and get rid of my scars. In the early days, I have scars that run down my torso from surgery. In the early days of our relationship, he had spoken about my scars as if they were a badge of courage. But then he also suggested that I get a boob job and get into shape. He made me think that I have to change how I look. He didn't like me talking on the phone, even though he was often on the phone himself. If he heard me on the phone in another room with the door closed, he would come, open the door, glare at me, and shake his head. I would try to wrap up the call quickly. During one call with my mother, she said, "You get very quiet when he's around. My friends notice when I try to talk to you." And there was his preventing me from eating certain foods. At a dinner party that coincided with Valentine's Day, waiters came by with plates of beautifully arranged hors d'oeuvres. One came by with a chicken dish. I really wanted to eat it, but because he was a pescatarian and was there, I didn't. He wouldn't let me eat meat in his presence. He glared at me and, out of earshot of anyone else, said, "I saw the way you were looking at that." It's almost ludicrous reading these words now. Another time, we were having dinner at a seafood restaurant on the Upper West Side. Complimentary chocolate pudding was served at the end of the meal. Chocolate pudding is one of my favorite desserts. Eric wasn't eating his, so after I finished mine, I asked if I could have the second one. The cup was quite small. He looked at me as though I were a misbehaving child and said, "Bad turnip." I felt as though I couldn't eat sweets and couldn't eat meat with him around. I cherished the nights I met friends for dinner. Whether I was in the mood for meat or dessert or not, I ordered both. His need to subjugate me extended to our sexual interactions. When he first slapped me in the face while we were making love, it happened in the blink of an eye. No man had ever done that to me. He seemed to be testing me. I didn't know what to do. I tried to make sense of it. I had thought of him as a meditator, someone who espoused spirituality and who fought on behalf of vulnerable people. At that moment, I became aware that he could inflict great harm on me. Over time, the slaps got harder and began to be accompanied by demands. In bed, he would slap me until I agreed to find him a young girl for a three-way. I told him what he wanted to hear, even though I knew it was never going to happen. He would slap me until I agreed to call him master or daddy. He recounted his fantasies of finding me somewhere far away to be his slave, his brown girl. I wondered what he called his previous girlfriends. The ones I was aware of were white. With me, he said I had wild hair and unsightly scars, and he wanted me to be his slave. Publicly, he was a friend and ally to communities of color. He was a big supporter and fan of jazz artists, but in the bedroom, he wanted to be master and slap around his slave. He would hurl spit into my mouth and mash his lips against mine so that it was hard for me to breathe. A few times he put his hands around my throat and tried to choke me. When I tried to move his hands, he ordered me to let go. I would say, "Hey, that hurts." I would tell him to stop, but he didn't respond to my protests. Each time he looked at me as if he were possessed, and then the moment quickly passed. I felt as if I had vertigo. I didn't realize it at the time, but I was dealing with the kind of abuse that can go on between people in committed relationships, intimate violence. I tolerated the situation because it was disorienting and so disconnected from the person he presented as in public. By day, he was the crusading attorney general, and he had to be nimble and sober. At night, as soon as he got home, he would start swigging from a bottle, usually wine, but sometimes vodka. I tried to get him to pour it into a glass so he could keep track of how much he was consuming. He would pour me a glass of bourbon and push it toward me, saying, "Drink your bourbon." Sometimes I would be woken up by his fingers inside me or his hands squeezing parts of my body. He seemed to be moving in his sleep and would say things like, "I love you," or "My bad, bad girl, daddy's going to rape you." I remember on a few occasions after he had passed out, I would go to the guest room and sit down with tears rolling down my cheeks. He started asking me to hide the bottles from him. I took the task seriously, but found it increasingly difficult to find a hiding place he wouldn't discover. Under the couch, behind the television, nowhere seemed safe. And then I thought, I'll put the vodka bottle deep in my bag of dirty laundry. But in the morning, the bottle was empty. He said smugly, "You didn't do your job." Don't be afraid. Don't be ashamed. I told myself every day in the months before my story of abuse became public. I had decided to come forward after I'd realized I was part of a pattern. It wasn't just my story, other women shared it, and I had to tell it to help prevent still others from having it become their story too. In early January 2018, I spoke with David Remnick, the editor of The New Yorker, about my experience with Eric. I gave Remnick my word that I wouldn't talk to other publications while he decided how to proceed. He told me that if I were alone in coming forward, I could be in peril. On March 20th, my birthday, New Yorker staff writer Jane Mayer called me at Remnick's request, wanting to hear about my experience in my own words. Then she echoed Remnick's opinion. If I were alone in coming forward, I could be in peril. She asked me to give her time while she tried to contact previous girlfriends of Eric. Within 2 weeks, she had spoken with 2 of them, and their stories were eerily similar to mine. At that point, I knew that the stories coming out was inevitable. Eric would often say, "Assume nothing." He would also say, "Trust no one." In my relationship with him, I went through the classic stages that structure intimate partner violence, stages that many victims go through and that Jennifer helped me understand. Entrapment, isolation, control, demeaning, and abuse. After the New Yorker article came out, I worked hard to understand how I had gotten into a relationship with a man who had made me feel so bad about myself. I had a long bridge to cross before I could be in an intimate relationship again. As a child, I had witnessed domestic violence in my home, my father beating my mother. I had never thought I would become a victim. A friend said he had been shocked about what had happened to me because he thought of me as fierce, independent, and an advocate for women's rights and safety. But when I met Eric, I was on a trajectory of recovering from a series of health issues, multiple miscarriages and cancer, followed by a divorce. I was secure with regard to my work and my friendships, but I was weakened with regard to romance. Then my path intersected with that of Eric, whom I would later discover had a history of breaking strong women down. I was ripe for the breaking. It was the perfect storm. I wish I didn't have memories of being a victim myself. No one wants such memories. But I feel that somehow the universe intended for me to encounter him and eventually end a cycle with his intimate partners that had been going on for a long time. I would later find out that it had actually been going on for at least 4 decades, which was much longer than the about 10 years I knew at the time the New Yorker story came out. In When Women Were Birds, Terry Tempest Williams cited the poet Muriel Rukeyser. What would happen if one woman told the truth about her life? The world would split open. Thank you for listening to my story. By doing so, you've helped me realize the power of my voice. Let's split the world open together.
Tanya, thank you so much for sharing your story. I feel like we all need to take a deep breath.
We can all do that.
I did. Thank you. There's so many, we spoke a lot about your situation at the time. And one of the things that you debated was, should I come forward? Should I go to the police? Should I go to family court? And one of the things we talked about was the fact that, well, there were a lot of reasons that he would be particularly hard to face in court. But also that many of the things he was doing came under the heading of coercive control and were not as easy to allege and not as easy to prove, and that you would be really scrutinized. So I think Tanya made
Well, I'm
really,
still being scrutinized.
yes, well,
But I can take it.
yeah, of course. But fortunately, coming forward was a good way for you to ultimately tell your story versus going to the police, for example.
Yeah, that was a non-starter.
Yes.
Considering
So
his position at the time.
yes.
But coming forward was really, and also I recognize very much then and now that I am privileged to have been able to speak out, because most people suffer in silence and most stories wouldn't have gotten that kind of coverage. So it was a strategic move on my part. But
Yes.
I knew it, and you and I discussed that a lot.
Yes.
In those months.
And I just like to say that I know that Tanya has received many, like thousands almost of emails and letters and communications from victims who have thanked her for telling her story. So we thank you, and I know they thank you as well.
Oh, I thank you.
So I'm going to turn to Anna Maria. So Tanya's experience, I'm sure, resonates with many of the stories of survivors that you've served in your legal practice. And my question is, so the name of this panel, I think, is something about aligning the law with today's understanding of domestic violence. We understand coercive control. We've just heard about it. Do judges understand coercive control?
Thanks, Jen. I'm very happy to be here and to be on this panel. I'm also in the very unfortunate position of following Chitra and Tanya, so I'm going to apologize in advance for not being nearly as compelling. This is the dry, technical part of the panel. So in New York State, coercive control is not a family offense. And for those who are not New York practitioners, just by quick background, in family court, in order to obtain an order of protection against someone, you have to have a certain type of relationship, be related by blood, marriage, or formally married, have a child in common, or be in an intimate partnership with them. And in addition to that, you have to allege and prove of what's called a family offense. And this is a list of specifically enumerated crimes or violations that are in the New York State Penal Code that have been incorporated into the New York State Family Court Act. So in order to get an order of protection, you have to prove that an actual crime or a violation occurred, something that violates the penal code. There is a crime of coercion, but it's not related. That's forcing someone to commit a crime or do something they don't want to do, essentially. But coercive control in and of itself is not a crime. The law as it's written in New York is very incident focused. As Chitra was talking about, it really relies on the victim or the petitioner alleging a series of incidents that, again, time, place specific, that are crimes. And as we all know, in reality, domestic violence, intimate partner violence is about a pattern of conduct. So under the current framework, there would have to be enumerated as a crime or a violation in the penal code, the crime of coercive control. It would have to be spelled out, defined, and then it would have to be explicitly incorporated into Section 812 of the Family Court Act as a family offense. We could also imagine an alternate framework where it's not necessarily a crime, but it is enumerated in the Family Court Act or in the domestic relations law and is defined and explicitly made a family offense, or at least made a factor to consider in determining whether to grant an order of protection or in custody determinations, et cetera. So those are the two sort of possibilities as how we could legislatively bring the issue of coercive control into our family courts. And in either framework, they could be made a factor in not just custody, but also in divorce cases, in equitable distribution and child or spousal support, et cetera. Now, the law as it presently stands has some room for addressing coercive controlling behavior, but it's very limited. What is typically not actionable, unless you can somehow creatively squeeze it into a crime, something in the penal code, are things like threatening suicide, withholding food, checking someone's emails, phones, social media, et cetera, withholding a get or religious divorce, or refusing to apply to adjust the immigration status of your spouse. Those are all part and parcel of sort of typical coercive controlling behavior, but none of those things are going to get you an order of protection. Also, this incident model, this series of incident models, does not account for big picture factors, such as, is the abusive behavior that's occurring, is it escalating? Or are there high risk factors in the background? Such as the unemployment of the abuser being unemployed, the presence of someone else's child in the home, et cetera. There's a number of high risk factors, which we're going to talk about in a bit, that, again, this incident model doesn't touch. So, and as Chitra mentioned at the end, which blew all of our minds, the burden is entirely on the victim to prove the case. If you're the petitioner, you're the one who has to bring all the evidence. And if you don't know kind of what your rights are, you don't know how to do this creative lawyering, or maybe your lawyer isn't well versed in this issue and you don't make that case, your judge or your adjudicator is not obligated to ask you anything. They can sit back and say, I'm sorry, the story you've told me is not sufficient. You don't get your order of protection, and that's that. Now, having said that, there is some room. Many family offenses do not require any physical contact, let alone physical violence. And you can fit, again, in this creative way, you can fit a lot of controlling behavior into harassment, disorderly conduct, menacing, reckless endangerment, stalking, coercion, and sexual misconduct, et cetera. So there's a number of enumerated family offenses that you can try to make work depending on the specifics of your case. There's also an opportunity in family offense cases to show aggravating circumstances. That is behavior that could get you, instead of an up to 2-year order of protection, an order of protection of up to 5 years. And one of the enumerated aggravating circumstances is any like incidences, occurrences, behaviors, et cetera, that constitute immediate and ongoing danger to the petitioner. This is very broad language. It's meant to be broad, and there's an opportunity to say to the adjudicator, okay, here's some stuff you need to know about this situation that makes it more serious. Now, the disadvantage to that using aggravating circumstances is that determination comes after your trial. You have already had to have established and proven that at least one family offense occurred. This is in the dispositional phase. The advantage, though, is that because it's in the dispositional phase, your evidentiary rules are a little bit relaxed. So if you can't afford in your trial to hire an amazing expert like Chitra to testify, in your dispositional phase, you might be able to introduce one of her publications about coercive control and why it's so dangerous and why it's so much more serious than it might appear on its face. Another opportunity is in New York, we allow extensions for orders of protection for good cause, and good cause is whatever you can convince the judge good cause is. So if you can convince the judge that coercive controlling behavior is good cause to extend your order, there's an opportunity there. Also in the custody context, domestic violence is a factor, a mandatory factor that the courts must consider when determining custody. And domestic violence in that context is not defined as family offenses, right? It's the much broader social services law definition of domestic violence. So there's an opportunity to show a much broader pattern of behavior than that limited family offense context.
And actually, and we're going to stop you there because I want to, is that okay?
Yeah.
Okay, great. Because I want to turn to California, where there is coercive control legislation, and that's where we're joined by Paula Cohen. And that last thing you just said, Anna Maria, is the perfect segue, because one question is, do we need coercive control legislation in New York in order to get orders of protection? Maybe yes, maybe no. When or why would we need it? And perhaps one of the best uses for it would be in regards to the following custody case, which we know often happens. So Paula, I'm going to turn to you and
yes, can you hear me?
Yes, we can hear you. Thank you.
Okay.
And just ask, what has your experience been in California with having this legislation as a practitioner?
Yes, so first, thank you so much for having me. My view isn't quite as spectacular as yours, but we did have rain here this week in California, so we're very excited. That's our first rain since last winter. So greetings from California. I can share my screen and you can tell me if you can see this. Can you see that?
Yes, it's small, but we can see it. And I think everyone online can see it as well.
Okay, I know there's a way to make it bigger. Oh, here, 100%. Let's see, 150%. Is that better?
Yes.
I can go 200% if you want a little bigger. Let's see. There we go.
Okay.
Is that helpful?
Yes.
Okay, I don't know how to cut this side part out of my screen, but we'll manage. So yes, it's definitely helpful. I bring you greetings from California, from a state where we have coercive control now on the books, and we use it regularly. What I would say is, as domestic violence advocates, we understand and have always understood what coercive control is, even if we didn't actually call it coercive control. We've talked for decades about isolation and manipulation, perhaps somewhat to deaf ears. And obviously, I very much appreciate Chitra's and Tanya's words. I feel like both of you have been sitting in our domestic violence clinic and listening to all the cases, because each case is completely unique, but has certain markers that make them almost the same as all the other cases. And Chitra very succinctly listed through those 8 things that are real markers of coercive control, and ones that we talk about in our domestic violence restraining order applications every day. What I'm hoping you can see on the screen, and it got cut off a little bit here, is the first part talks about the totality of circumstances. And that's huge because it provides context, which is what Chitra was talking about. It's very miserable, but very easy to describe a client who was threatened with a loaded gun. We can do that in 2 sentences. We can make it terrifying. We can make it visually, very imaginable, almost touchable. We can do it in a very few words. But coercive control, we can't do in a very few words, because as Chitra was explaining, it's the whole pattern of the relationship. And the clients come to us without the vocabulary to describe it. So having a checklist like the one that was already provided this morning, or there are many other coercive control checklists you can find online, having a checklist like that and kind of asking softly, quietly, patiently with the client if any of these things have happened, slowly you begin to paint the picture of coercive control. What I love about our California statute, and I hope you can see it on the screen, the bold is my bold. It's not highlighted in bold in the statute, but what I love is our statute uses particular vocabulary that we can cite to in our applications. So it gives a non-limiting list of examples of what coercive control might include. And I hope you can see on the screen that that includes isolating, depriving, controlling, regulating, monitoring, compelling, etc. You'll see words that you saw and heard in Chitra's list, a checklist of coercive control. And we use those words in our declaration. So if we're describing the isolation, we can spend a few sentences talking about how he never let her out, he didn't let her look at the clerk in the grocery store, he didn't let her work, all of those things, and we can actually cite to the statute. So if you're proposing a statute in New York, I would say the vocabulary and the non-exhaustive list of examples is super, super helpful. I also want to address, and I'm going to show you some photographs. Oh, that's not what I want. Some photographs of text messages. We almost always use text messages now in our applications for restraining orders because it's such a fertile ground for examples of violence, abuse, and coercive control. This one on the screen you'll recognize as a very, sadly, typical kind of domestic violence threat. Any restraining order that we have that kind of text to attach is going to be granted. In California, we have to show actual violence or a specific threat of imminent harm, and obviously that qualifies. But when it comes to coercive control, I thought this one was a good example. I realize you may not be able to see it on your screen. So I'm going to explain that this text came from a client who was a doctor in her country of origin, as was her husband from the same country. And they came to the US. He came first, was already licensed in California, and then he married her in their home country, brought her out with the promise that she would also get licensed and they would both be able to practice medicine in California. Well, he pretty much locked her in the house. There was horrendous sexual abuse that she definitely did not have the vocabulary to describe and certainly didn't want to at any length on the stand. But we had this text that I thought was so helpful for coercive control. He says when he's coming home from work, she says, let me know when you're on your way. And then he sends her a message, why you open the door? Well, first of all, how did he know she opened the door? Because he had cameras everywhere. This is a doctor working in a hospital with a very important, impressive job in California, but he had cameras on his wife at home to find out what she was doing, to know at every moment what she was doing, and she was not allowed to open the door. So he sent her a text message, why you open the door? She said, I thought my package came, and he sent her that emoji. Now, it's only an emoji, but I think that's a pretty terrifying emoji, and we made that argument in court. That emoji holds in it the whole, if you look at the totality of circumstances, the whole threat of how he might be responding and treating her and abusing her when he gets home. He sends that emoji and she clarifies about the package from USPS, from the United States Postal Service. And he resent the angry emoji with a what and all those question marks, if you can see them, like a super angry, as if he's shouting, as if it's in all caps. And then don't open the door when I'm not there. And we use this as an example of him isolating her, even though she was, well, there's no excuse. We used it as an example of him isolating her, and the judge totally got it. I have one more text from that relationship, which is about how she was studying for the exam to become a licensed doctor in California. But when he went to work, he cut off the internet so that she could not study while he was gone. And there's a series of texts when she starts getting stronger and bolder and starts kind of standing up for herself for a long time this happened and she didn't do anything. But then there's a series of texts where she says, I'll never forget that you did this to me. And he tells her she has to learn to speak respectfully, to talk with people respectfully. And it carries on with him telling her about how she's supposed to dress and how she's supposed to speak with clerks in stores and things like that. So I'm going to stop sharing so I can hopefully see you, or at least see the panel, and say that it's extremely valuable to have the code. Just so you know, the first countries to enact coercive control as part of domestic violence were the UK and Wales. So proud of my home country. That was in 2015, and then Hawaii in 2020, and then California in 2021. So there are several countries and states that New York could look to see how we've done this. I would say we haven't had it long enough yet to know exactly what the problems are with the language, but using the language of the code is extremely helpful. And I certainly encourage New York to press forward, because I think it's easy for us to say, oh, the judge doesn't get it. But it's our job to educate the judge and to tell our client's story in a way that helps the judge to understand. Actually, before I finish, I did want to share one other thing. So let me just share this screen, and then I will finish, Jennifer. This is an extract from a book called In the Dream House by Carmen Maria Machado. I actually tend not to read a lot of things about domestic violence or watch movies about domestic violence because my whole career is filled with it and I like to have my off time be off. But I felt that this book so powerfully gives context to coercive control, that if you wanted to understand it better and if you wanted to understand how to express yourself to a judge, I think Carmen Maria Machado's book is just so powerful. She really is wrenching in the way she describes the psychological abuse. And this example, I'm not sure if you can see it. I can read to you a couple of sentences. She says, you have this fantasy, this fucked up fantasy of being able to whip out your phone and pull up some awful photo of yourself, looking glazed and disinterested, and half of your face covered in a pulsing star. This is, as you said, fucked up. There are probably millions of people on the blunt end of a lover's fist who pray for the opposite, daily or even hourly, and to put that sort of wish into the universe is demented in the extreme, but you will wish for it anyway. Clarity is an intoxicating drug, and you spent almost 2 years without it. I think that quote and so many things in that book help for us to understand how all-encompassing, how controlling, how paralyzing is coercive control. And it's our job as advocates now in California to use the legislation, to use the code that we have to help bench officers understand the psychological abuse that our clients are suffering and to get them the protection they need. Thank you so much for including me. Back to you, Jennifer.
Thank you, Paula. And I'm just gonna chime in that when Paula and I were talking about this, putting together this panel, we spoke with an attorney in California who had used the new coercive control legislation to get an order of protection on behalf of an Orthodox woman because the husband in that case was denying her the get. And the denial of the get, she litigated thoroughly and showed that it constituted coercive control. And that was the basis of getting the order of protection, which was quite extraordinary. She, by the way, is an amazing attorney, and it would have been too far off the field to have her join us for this panel. But I encourage folks, I believe in the CLE materials, we have that decision. And that's just another example of maybe a creative or interesting way that New York could potentially use coercive control legislation. I'm going to move on to lethality because this panel packs in a lot of really intense concepts. So understanding lethality has become crucial to our understanding of domestic violence and the level of risk that survivors face. And those of us from domestic violence agencies here, most of our agencies have incorporated utilizing some kind of an assessment. Dr. Raghavan, I'm going to start with you again. Can you
Yes.
define lethality and talk about what it means for
I
victims?
can, and I need my PowerPoint, and I need to be near my PowerPoint because I
Okay.
won't be able to read it.
Go
So,
for it.
Mr. Penny, thank you. A long time ago, I gave up doing unstructured talks because my mind digresses like a river tributary. And if I don't have a PowerPoint, you will hear many stories, and all quite irrelevant to lethality.
Oh, it's possible that our
Ah,
oh, Jeff, do we have the PowerPoint still, or did we lose the PowerPoint? Oh, they're bringing it back. Okay,
you might have to close your eyes for a minute. Ah,
Nope,
it
there we
goes to
go.
right there. Lovely.
thank you.
All these references because, of course, you'll read every single article. So what is lethality? The way we define it is that it's severe aggression with the capacity to injure or kill the victim. And I think what's important to know is that for every completed femicide, there were 9 near-lethal incidents. In other words, and there's many more than we think, but 1 person died and 9 didn't, 1 woman typically. There is no difference in the level of violence between the 1 woman who died and the 9 who didn't die. And the difference was chance. He was interrupted. Somehow somebody called the police, or she just didn't die because she fought hard. And why this is important is it's not as infrequent as we think. If for every 1 completed 9 didn't die, it's very, very high. I want to, as an aside in my tributary river divergence, say that, no, not yet. 60% are by gun in the US, that's not surprising. But what's also equally interesting is 16% is a sharp instrument, anything that he can find in the house, typically a knife, but also bottle shards, whatever is sharp. And another 20% is strangulation, beaten to death, or very, very rare incidents such as being run over repeatedly by a car or thrown out of a balcony or drowned. Those are so rare that I think, what we should really think about is 60 gun, 20 sharp instrument, 20 strangled, so using his hands. I do want to say that there is a very high unknown serious lasting physical injury that might qualify as near lethal that we don't know about, or have brain damage, chronic pain, all kinds of pelvic damage from very rough and violent rape. And it doesn't show up. And my PowerPoint's gone away.
It's back.
Something odd is happening. Okay, never mind. What are the risk factors? There are no risk factors for women. That's really important to know. What are the risk factors for men? This is so vague, it's unhelpful. Unemployment and substance abuse. But really, lots of men are unemployed and lots of men drink. So, it's really, if you come very close to it, it's important, but in the bigger scheme, it's unimportant. But there are a lot of different violence pattern risks that are important. And I think the way to think about this is when those violent risks begin. So one thing that we see over and over again is the control escalates, and so does the jealousy. And so measuring escalating, not just escalating control, but escalating jealousy is useful depending on how close you are. And repeated threats to kill or injure, there's going to be repeated threats, and sometimes it's veiled, but sometimes it's direct. Such as, do you remember the last time I did this? Do you really want that to happen again? And the last time might be when he choked her. Using, of course, a gun, pointing a gun, touching a gun, looking at a gun, those kinds of things, or even access to firearms in the house. He doesn't have to have ever used it. I've had lots of perpetrators just put the gun by the bedside, for example, and smile. Right. And choking or strangulation. We don't have the odds ratios, but it happens more often than we think in later on women who would survive. It also, by the way, if you work with same-sex violence, and I do considerably, there's a great deal of choking and strangulation. Rape and stalking. So what tends to happen? There's 2 patterns. One is the rape started early on. And by rape, I'm using it loosely and psychologically and not precisely as a lawyer would, but sex that you didn't like and the way that you didn't want, that you didn't ask for, that you felt you couldn't say no to. There's 2 patterns. One is it starts early on, but the other is either in a ho-hum sex or intimate sex, starts to turn violent in the middle, and jealousy around this. The jealousy starts to come out in different ways. There's a pattern change in rape. And if you have a child from another man, and or if he was violent during pregnancy, these are very high risks as well. Oh, that shouldn't have happened. That's okay. I'll stop. So what I wanted to talk about quickly were triggers. What are triggers? It's consistent across gender. It's consistent across countries and culture. Is you're trying to leave him, and he thinks you're trying to leave him. So both of these are equal. Trying to leave him is if you're starting to make steps to leave, it starts to, the violence explodes. That's when the jealousy, the stalking, the rages. When he thinks you're trying to leave him is often sort of the pathology of the abuser and the paranoia and the jealousy that go into it, but it really doesn't matter. If he thinks you are, there's an escalation of violence.
Thank you. Tanya, can you tell us how an understanding of lethality impacted your situation?
The lethality felt like a very distant concept to me while I was in the relationship. But it was, as I was, I mean, that was when you and I were in a lot of communication and decided rather than to kind of like have an active breakup or announcement that I was leaving to drift. It was one of the most bizarre breakups actually, because I just drifted. I started going away to a point where the best scenario we felt would be that he ended things so that he had agency over it. But what became very clear to me in conversations with many, many friends who had situations far more horrific than mine is that it was at that point of leaving that they felt they were most in danger. You know, a friend who would sleep with a kitchen knife beside her, scared that she was going to be attacked. A friend who had gotten her ex-husband arrested, and he was giving her number to inmates to taunt her. And so these stories were fresh in my mind when I was trying to figure out what to do. Did I think I was in actual physical danger? I think you can't anticipate how far somebody will go once they snap, once they feel everything is being taken away from them. And we've seen time and time again how those situations weren't anticipated and ended up with tragic results. So for me, it was preparing myself for all possible scenarios. The optimal being the drift, the worst being the snap. And so I did everything I could to, and I was very fortunate that I had people around me who had my back, that I had you, that I had my friends, that I had work to go to. I was in an office where I felt safe, but so many people don't have those outlets. So I learned a lot about how to keep myself safe. And also one of the reasons I wrote the book was to give people, and you and I collaborated on the resources to help people see like how to protect themselves. And one thing that I did at the encouragement of another friend is I did a physical and virtual safety training. You know, and that was mind-blowing to me when I did that and realized like all the potential danger points, both physically and digitally, that I could be susceptible to. In particular, because of the position that my abuser was in, the resources that he had at his disposal, and we've seen how, you know, in positions of power, so many perpetrators have used them to really insidious and nefarious results. So
Well, it was ironic, right? Because on the one hand, he made that, joke, well, I can have your phones tapped and I can
he
have you
also said
arrested.
he also asked many times if he would have to kill me if we broke up.
Mm-hmm. Yeah. On the other
Which
hand,
we said as a joke.
Yeah. So that's frightening.
Yeah.
Yeah. So thank you for sharing that, Tanya. Anna Maria, so we're talking all about lethality. We've also talked about coercive control, but these are understandings within the domestic violence field. Like, this is basic. Again, I hate to ask maybe an obvious question, but does family court, do judges understand lethality? Has this understanding of what makes a situation so frightening, is that actionable?
So similarly to coercive control, there's room in the law as written to address some of these lethality indicators, but it's not explicit. And so much depends on our judges, our referees, our adjudicators' understanding of the issue. They have great deference here. And the reality is, even though our laws are written with some flexibility, and the intent is to provide the strongest protections for victims of intimate partner violence, because our judges vary so widely in their understanding and their willingness to sort of take these issues seriously, you will find people have widely different experiences in family court, ranging from the pretty good to the absolutely horrific. And we've heard some of the most horrific today. Many judges still focus on physical violence at the expense of other abusive behavior. The idea being, well, if you can stop the physical violence, then we're good, we're in a good place. So if I give you an order of protection, you're safe now, and now we can move on, right? Now we can move forward. And that focus also extends to the impact on children. The focus is often, well, what actual physical violence did the children see or experience, as opposed to the bigger picture of what is this family dynamic? And there's still a lot of deference in family court to the authoritarian parenting style, which can provide a lot of cover for controlling abusive behavior. Just the idea being, well, this is just a really tough, strong parent, and that's what we need, because otherwise, kids can get wild and get out of control. So again, while I said there's a lot of room, you can find yourself in court making these arguments and you feel like you're just coming up against a brick wall over and over again. And it's not just an issue with judges. This is an issue at every level: attorneys, forensic evaluators, police, ACS, all kinds of important players in the system have this similar lack of understanding, where again, their focus is what physical violence is there and how do we stop that? And once that's resolved in their minds, they're done. So the other problem is, even for a judge who has some understanding of the issue, there's nothing in the law that says, okay, judge, here's the time and place you must assess lethality or other high risk factors, and here's how you do it, right? So it can just be put off, right? So even if you have a judge who gets like, yeah, at some point we're gonna have to sit down and talk about the risk situation, when is that supposed to happen? Ex parte, when one person is there alone going in asking for help, the first return date, the first time you're talking about custody, the first time you're talking about visits, when? That's not really clear. And so that can be delayed, and that delay can lessen the urgency of the situation. So you have a client who's now self-helping, right? Because they're not getting what they need from the court, they've now moved into shelter and they're in hiding. And so from the judge's perspective, well, you're safe now, you're at a shelter, you're at a confidential location. And as the advocate, I'm saying, wait a minute, if safety depends on my client being in hiding, that's not safety. That hasn't changed any behavior. That hasn't changed the mind of the abuser or held them accountable. That's just changed the circumstances. That's not real safety. So you may find yourself arguing things, and also, again, so much depends on your judge's understanding of the issue. So if you can't fit the behavior that is raising concern into a family offense or connect it to physical violence, you may be facing a judge who just isn't seeing it. So you may be arguing, judge, I'm very concerned. The abuser is unemployed, facing financial ruin. There's very controlling, jealous behavior that's escalating. My client's being surveyed. I'm very concerned for my client's safety. Some judges will get it. They'll say, okay, this is a very volatile situation. We have to proceed very carefully. But many judges will push back on you. Counsel, being unemployed is not a crime. Why am I hearing this? Tell me what the family offense is. Tell me what the actual abuse is. That's what I have jurisdiction over. I don't want to hear this other stuff. And so you're stuck because you've lost, you no longer have that opportunity to say, here's why the situation is so volatile, is so dangerous. So again, even where there's room, our clients are entirely dependent on us as advocates understanding the issue, as well, and making that case, as well as all these other players understanding the issue and taking it seriously.
So we heard from Jacqueline Franchetti this morning about Kira's law, which requires, and this is a bill that's pending in the state legislature, and it requires an initial safety assessment. And there's interesting language around what that might entail. It's primarily intended for safety of children in custody cases, but it would require judges to consider multiple factors, a variety of factors, and not just whether a family offense has been committed. Anna Maria, how do you think that would impact what you just described?
I think it could be very helpful in a couple of respects. One, again, it's the timing, right? The idea in this proposed legislation is this has to happen immediately with some urgency. So it gives judges a sense of like, here's when you're supposed to do this. And that can make a huge difference, especially in a very overburdened court where there are constant adjournments, you have very little time. If the judge knows, okay, on this appearance, I have to do this risk assessment, I have to make the time for it. The other important thing about it is legislation can sometimes force an issue, force a judge who might otherwise be very, recalcitrant on an issue to take it seriously. You may have a judge who says, look, I don't get this coercive control stuff, but I follow the law. If I have to have this hearing and I have to look at these factors, I'm going to do it. There are many judges who are very sort of formalistic that way. Another thing is having that legislation can really prompt judges and other adjudicators and other players to say, okay, we have to do this thing now. I want to understand it better. How can I do this if I don't understand the issue? And that encourages them to be involved more in training. And I'm not just talking about the formal judicial training process. There are a number of task force working groups, other advocacy type groups that judges participate in, attend, pay attention to, and that can hopefully foster some communication there as well. If there's this new coercive control law or new risk assessment law, I need to learn more about it because I have to start using it essentially. I will say though, I'm very skeptical about relying too heavily on legislation in this manner because I feel very strongly that we're only setting ourselves up to fail if we get legislation like this passed, but do not correspondingly provide the resources to the courts to do the work we want them to do. Even the best judge cannot do a proper risk assessment or assess for coercive controlling behavior if they only have about 10 minutes per case. Even the best judge can't do what we need them to do if adjournments are 6 months apart. Even the best judge cannot do what we need them to do if they know what I say in this courtroom is not going to be reflected outside this courtroom. This family needs certain services, this victim needs certain services, these children need certain services, but when they leave this courtroom, they're not available. So one, very strong hesitancy I have is that legislation is great, resources are equally, if not more important.
Thank you. So we're moving fast and furious through a lot of very intense topics, which we could have an entire conference on. But I do want to also talk about femicide. And Stephanie was sitting over there, but now she's not. There she is. She's hidden from me. Stephanie did an amazing job educating us and forcing us to look at and think about the thing that we're all the most afraid of, which is that our clients will be killed and that a femicide will take place. Domestically, we know that this is a critical issue of gender and racial justice, as well as trans rights. Rates of femicide are higher among trans women, Black and brown women, and Native American women. Domestically, there have been important campaigns shining a light on the disappearance and murders of Native American women and girls in particular. And I encourage folks to look in the CLE materials to learn more about this phenomenon. here in the US, we have very intentionally begun using the term femicide to join the global movement. In New York City, practically a week does not go by when there isn't a domestic violence related murder reported, yet they all seem to be described in the media as discrete individual instances of just kind of random acts of violence and not part of a pattern of gender-based violence. So Chitra, turning back to you as our educator, can you talk with us a little bit about your research and how we can understand femicide?
Sure. I want to make maybe 3 points. Let's see if I can do that. And the first is that femicide, which is the murder of women, is not as a result of the escalation of physical violence. That's an error. It is as a result of a escalation of control. So if you think back to the abuser needs to be correct and the abuser needs to be affirmed. If he can no longer be correct and he can no longer be affirmed, what does he do? Many men get younger wives. Others go to prostitutes or sex workers, others drink, but a handful kill the source of what makes them feel that they're wrong. So it's an escalation of control, and so we have the beginning of studies showing that coercive control is a much better predictor of lethality than is physical violence alone. And I've just completed a study with a brilliant young Spanish psychologist in Spain looking at Spanish femicides. It's eerily similar. We find the same data, that what predicts women dying in this sample is the escalation of jealousy, stalking, for example, control. So look at coercion, not just physical violence. The second point bolsters the first, which is in about 30% of femicides, and that was true in the Chicago data set, which is what we base a lot of our information from, but also what we almost replicated the same thing in the Spanish data set. 30% of the women had no discernible signs of physical violence. So, you know, the investigators, the team talked to family in both studies, friends, networks. They talked to everybody that they could, and all of them said either we didn't see it, we didn't know it, or it didn't happen. And some of it is, of course, it wasn't recorded because she was afraid, but some of it is that probably wasn't that kind of physical violence, a little bit like Tanya Selvaratnam's case. What there was control and sexual violence, which wasn't reported. And so you will have cases where there's no physical violence, but there's increasing control. And, you know, you need to sort of look at that pattern together and maybe keeping at the back of your mind this idea that the abuser doesn't want to lose not because he's controlling, right? That's circular. That doesn't help you think. It's because he needs to be affirmed that he's correct. And if he's not affirmed as correct, then what does he do? He sets about to make sure that that source of affirmation goes away, is silenced, is humiliated, goes to jail, you know, is countercharged or is killed. And so, yes. That I have a minute left and I will stop.
Oh, I think actually, yes, that's the time for before the Q&A, but I think we're going to take a little bit of the Q&A time because we have a little more left to discuss, but I am going to interrupt us briefly to give all of our online friends the code. Which is for CLE, and that is, I'm supposed to read this. For attorneys participating in this program remotely, please note the CLE passcode is F4EM, like Mary, Y6. F4EMY6. This code must be included on your CLE form to submit for credit. Okay. So thank you for describing femicide and some of the warning signs or evidence-based factors that may give us a sense of the more at-risk cases. Anna Maria, how do you see connecting femicide with your work with survivors?
Well, it's interesting. I actually wanted to talk about something else that's very like a big issue of mine, in that there's a major connection between domestic violence, intimate partner violence, femicide, and mass shooting. And it's something that we just don't address. We don't talk about it. I don't mean we in this room, I mean culturally. We are a gun culture, again, not this room, but largely we're a mass shooting culture, unfortunately, and we are a culture that generally speaking does not take abuse seriously, especially abuse against women. And so when you have this backdrop, there's a reason that while other types of violent crime have gone down, the rates of IPV and intimate partner violence related homicides sort of stay stubbornly consistent. And so there is this very direct connection, and once you see it, you can't unsee it between intimate partner violence and mass shootings. There's materials in the CLE materials, there's articles about this, including some research. And I also linked to a podcast, You're Wrong About, that did a deep dive into the DC sniper case, which got a tremendous amount of coverage in the late 90s when it occurred, but very little coverage about the fact that it originated as a domestic violence case. Mildred Muhammad, the wife of the DC sniper, John Allen Muhammad, had gotten a divorce and gotten an order of protection against him because he had been very controlling, very emotionally, verbally abusive, and she was quite scared of him. In response, he kidnapped their children. And when she finally tracked them down, got her children back, got custody back, she went into hiding in DC. And that's when the murder started. And the police finally pieced together that he was hunting her down and killing people as cover, so that when he finally found her and murdered her, it would just look like a random act of violence. And the podcast goes into real detail about the whole history of the case. But for me, what's so striking is that part of the story always gets just sort of pasted over, ignored, not really explored. And it's the whole impetus behind the entire thing. And it's amazing to me that we don't want to talk through and address the connections that exist. You know, a few voices in the media sometimes raise it, but it dissipates very quickly. And there's little to no attention paid to it politically. Yes. Thank you. So how it connects to my work, to our work, is that we don't make these connections in the courtroom either. We don't talk about, Your Honor, if we don't address this violence here now in this family, where else might this go? And that part always sort of gets the short shrift. It's the violence in the family is always sort of treated as this very narrow, contained thing. And again, once we can stop the physical violence, we can move on and start talking about more important stuff. We can normalize the situation, we can normalize visitation, and we can just move on as if nothing happened. And in fact, we need to think more about what are the larger consequences to our neighborhoods, to our communities, to our culture when we allow this kind of violence to go unchecked.
So thank you for pulling the camera back a little bit and looking at culture. And that's a perfect segue. Tanya, you are a producer and writer in the arts, and Anna Maria is talking broadly about culture, and our culture is becoming more and more visual, focused on video, looking at videos on our phones a lot. How do you see today's themes, all the things we've talked about, as manifesting in pop culture?
I think until we get at the root of the normalization of violence, which begins from the time we're born, until we do kind of like a collective mass healing to excavate the generational trauma that we're born into and that we perpetuate, I think that we're doomed. I think that I think pop culture, like popular memory, needs to keep being reminded about the ways in which it conditions people to accept violence. And for every stride that's made, when people celebrated when films that, you know, I enjoyed but found problematic, like Promising Young Women, or a series like Dirty John, which was incredibly highly rated, that showed domestic violence, femicide. These shows are celebrated, but they largely center white characters. And I think too often popular culture, popular narratives forget the disproportionate impact that these issues, health, safety, rights, have on people of color and women of color. And so when you look at, for example, the fact that many mass shooters are also perpetrators of domestic violence, you also have to look at the fact that the majority of homeless people are victims of domestic violence. The majority of incarcerated women are victims of domestic violence. And these facts are not a coincidence. And gender justice is, for me, a very integral component of racial justice. And until we can really kind of begin to envelop those from all sides, there's subjective reality and there's objective reality. And in these situations that have been described, there can be many subjective realities. In my case, there were many subjective realities. There was his reality and my reality. And it was hard for me to see what was the true reality. But objective reality starts to emerge when you see the patterns, when you can talk to experts outside yourself. So where I feel the storytellers really need to step in is in accurately representing these stories to show all the different perspectives and not to be scared to keep reintroducing the issues. Because like repetitive messaging is super effective, and it's something that those who are opponents of gender justice are really, really smart about. And that those who support gender justice, who support reproductive freedoms, have been a real disaster at, have really failed because they haven't gone to the root, inculcating people when they're young, when they're in preschool, when they're in kindergarten. Like we need a whole bunch of children's books that advocate for gender justice and reproductive freedom. So that's where I feel like popular culture needs to step in, and also to stop glorifying these like white-centered stories of violence and femicide that kind of ignore the vast majority of the reality of these cases. And also we have to recognize that popular culture, like popular memory, is also very short-lived. So where people might celebrate a win, like with Harvey Weinstein or Bill Cosby going to jail, a few years later, MJ's nominated for like a bunch of Tony Awards. Felicia Rashad is accepting a Tony. I mean, all respect for her craft, but she enabled a predator. So like we have to be willing to call out the enablers and to encourage bystanders to be upstanders. But I have a pretty cynical view of how much we actually, walk the walk.
Jennifer,
It's
could I
amazing.
jump
Thank
in?
you.
Could I jump in with one
Tanya.
comment about femicide? Can you hear me?
Yes.
I just wanted to jump in with one really interesting resource. So there's a project in Israel that's called Listen to My Voice, and they use artificial intelligence to create videos of women who were murdered by their abusers. So they work with the families of women who were murdered. They get photographs and video of the woman who was murdered, and they use actresses for her voice. And they've created a series of videos that have been seen all over Israel that has the woman appearing to be alive and telling her own story about how she was murdered. It's absolutely fascinating. And the website is listentomyvoice.net. listentomyvoice.net. And they have some sample videos on the website. There are women of all ages, backgrounds, religions, cultures, ethnicities. At least one of the videos is in English, and the woman was a kind of well-known media addressed murder because the woman was a social worker, educated, middle class, etc. But in terms of getting stories out about victims, I was thinking about what Stephanie McGraw was talking about earlier. In terms of getting stories out about victims, the project is looking for other families to work with in the US, to expand to the US. They told me they're not looking for money. They're looking to work with families of murdered women from domestic violence to be able to tell their stories. So it certainly may be something of interest to this audience. I have no stake in it whatsoever, but it's another way of telling these stories. Listentomyvoice.net.
Can I say one quick thing
Sure.
that I do want to bring up? There were two stories in in the last few months, we've seen such an erosion of gender justice on so many fronts.
Yes.
We are heading in a very, very, very dangerous way. But at the same time, like with the loss of the reproductive freedom, with the constitutional right to reproductive freedom, with the brutal murder of Mahsa Amini by the morality police, with the order by the judge in Piper Lewis's case for her to pay restitution to the family of the man who trafficked her and raped her, whom she killed in self-defense. Like, these stories, these are all just in the last few months. And but what these stories do is they also, thinking from a cultural perspective, they also bring a lot of attention to these issues. So there are some positive signs, like with the surge of women registering to vote after the leak of the Dobbs memo, with the Kansas vote being like overwhelmingly going against that abortion ban, and with women worldwide taking to the streets in solidarity with Mahsa Amini. So I feel like these are things we have to harness more. Like, we need a global war between feminists and patriarchs. And
Thank you,
that's what I would say.
I agree. Amen. I have sadly 4 minutes left for questions, because this was such a rich conversation that I just didn't want to rush us, but I do wonder, Stephanie, do we have some questions that we should acknowledge our audience?
We have one that was asked a few times, so maybe we should
Okay.
start with that question. Can everyone hear me?
Yes.
Okay, so we got this a few times regarding what we've talked about earlier today, bias in the court, lack of training and understanding among judges. Is there a concern that criminalizing this new broad concept of coercive control will result in clients or victim clients having orders of protection issued against them? And to Paula, are you seeing this in California?
So first, I would say yes. It's always a double-sided sword. It's always a risk. And yes, we see clients being arrested and prosecuted for crimes related to domestic violence where we believe they're clearly the victim. I have not yet seen one that's focused only on coercive control. Typically what happens, and if you think about a typical relationship, our client isn't going to be using the manipulating, isolating, degradation tactics. Our client is going to fight back, probably physically, and that's what she'll be arrested for. So I haven't yet seen coercive control used in that way, but every single time there's legislation about domestic violence, it's used as a double-edged sword, and our clients do get arrested and prosecuted for it. And
Anna Marie, I'm going to ask you, do you see a way to consider coercive control legislation that would not involve the criminal justice system? In other words, do you see a way to include it in Article 8 of the Family Court Act without making it a crime in the penal code?
Yeah, absolutely. It doesn't necessarily have to be made a criminal offense. It could be made part and parcel of the Domestic Relations Law and Family Court Act as, again, a pattern of conduct, a factor for courts to consider in custody, in divorces, in determining disposition of an order of protection or even a neglect action. So a criminal statute is not required for us to act on it. I will say, though, I think Tanya and I are members of the founding members of the Cynical Critics of Pop Culture Club, because I do think any good can, in fact, be used by abusers and manipulated to their own advantage. So yes, it is very possible. Whatever good we can do in getting movement on this issue forward can, in fact, be manipulated by abusers to their own advantage, because that's what always happens. So yes, it is very possible. That doesn't mean we don't still strive for progress.
I'm going to say, if there's one more burning question you have, do you?
I have, or
I mean, you have.
I mean,
in there.
A question we also got a couple times is regarding lethality factors, which we've discussed are based on femicide rates. Should lethality be assessed differently when it comes to other victims, male victims, victims in same gender relationships, or children?
We don't have good predictive studies on same sex, so we have to use clinical data for the moment. And I think we should be assessed the same way for now. I don't know if we can ever actually get good statistical predictive data, because for that to happen, you need large populations of men who are abusive to men and who kill them, and large populations of women who are abusive to women and kill them. And just given the sort of breakdown of you know, the stats say 10, but I'm going to say 15 gay to non-gay. I think we're just not going to get that so clinically. But to sort of preface that, you should be doing it clinically is not the right term. Lawyers can do it too. Close to the person. So statistics just tell you a rate, but when you're actually doing assessments, you should be doing threat assessments, just different from risk, and look at those threat assessments closely. So I would use the same factors as you use male to female, as you would male to trans or male to male.
So I'm going to have to stop us here because we need a break before our next panel. So thank you so much to our panelists. Thank you.